Of the Subcommittee on the Constitution, Civil Rights, and Human Rights will come to order. Today's hearing will examine whether a number of new state voting laws imperil the right to vote. This year, we've watched young people in places like Egypt and Tunisia take to the streets to fight for what we in America often take for granted, the right to elect our leaders. In our country, regardless of how big the disagreement, how intense the debate, we settle our political differences at the ballot box. We have enshrined the right to vote as one of the major rights that every American citizen qualified has. But over the course of history, we know that that right has often been honored in the breach. Only in the last century did Americans win the right to directly elect their United States senators. And for more than half of the life of our republic, a majority of the adult population, the women of America, were not allowed to vote. Even after the franchise was legally expanded for close to a century, a well-organized, violent, often racist campaign successfully prevented many African Americans from exercising their right to vote. Fortunately, our country, over time, corrected and learned from these mistakes. In fact, our Constitution has been amended more to expand and protect the right to vote than for any other issue. 6 constitutional amendments, the 15th, 17th, 19th, 23rd, 24th, and 26th, ratified over the course of 100 years, underscore our nation's commitment to ensure that all adult citizens enjoy free and full access to the ballot. Courageous Americans fought for these constitutional amendments in order to guarantee the right to vote for all citizens, regardless of their race, sex, class, income, or state of residency. We must be constantly vigilant against threats to those hard-fought victories. That's why earlier this year I held a hearing on what I consider a threat to our democracy posed by the Supreme Court Citizens United decision and the flood of special interest cash into elections, and the need to fundamentally reform the way we finance our campaigns. Today, we're going to examine another potential threat to our democracy: recently passed state voting laws designed to restrict voting. I am deeply concerned by this coordinated, well-funded effort to pass laws that would have the impact of suppressing votes in states like Wisconsin, Texas, Florida, Indiana, Georgia, Alabama, Tennessee, and South Carolina. Regardless of the stated intention or goals, many analysts believe these laws will cause widespread voter suppression and disenfranchise by making it more difficult for millions of disabled, young, minority, rural, elderly, homeless, and low-income Americans to vote. Let's take a moment to consider some of the new restrictions on voting we'll discuss today. Since the beginning of this year, 7 states have passed laws requiring certain forms of photo identification prior to voting. At first blush, it might appear that ID requirements are reasonable. After all, who can't produce an ID? There's an old saying that applies here: the devil is in the details. The way these laws are written, not just any ID will do. According to numerous studies, millions of Americans who are currently eligible to vote do not have an ID that would satisfy these new restrictive laws. And these individuals are disproportionately young, low-income, senior citizens, African Americans, and Latinos. It is unclear what, if any, efforts are being made to make sure that those who do not have the required IDs will be able to obtain them before the next election. Some states have also passed laws drastically reducing the early voting period. Early voting is primarily used by our fellow citizens who cannot get to the polls on Election Day for a variety of reasons. They may not have reliable transportation. They may work at a job that does not allow them to take time off. They may have trouble finding child care. If they're disabled or elderly, they may not be able to count on receiving the assistance they need to get to the polls on Election Day. For these reasons and many others, the number of people voting early has increased with each election. In 2008, for example, 30% of all votes were cast before Election Day, which causes one to ask, why are some states reducing the early voting period when the number of early voters is clearly on the rise? Finally, there are 2 states, Florida, Senator Bill Nelson's state, and Texas that have enacted laws that threaten to end voter registration drives by nonpartisan groups. The Florida law places onerous administrative burdens on volunteers who sign up to help their neighbors register to vote. If a volunteer fails to meet a series of administrative requirements, they could be prosecuted and fined. This law is so bad, for the first time ever, the League of Women Voters, a highly respected, nonpartisan organization, indefinitely suspended all voter registration drives in Florida. These are just 3 examples of laws that could seriously impede voting rights in America. The proponents of these new restrictive state laws argue they're all about reducing fraud. Yet, as Professor Levitt, a witness on our second panel, has demonstrated, the incidence of voter fraud in America is minimal, and the reported fraud is often anecdotal, unsubstantiated, and contrived. I'm particularly concerned that the states where these laws were passed have not taken adequate measures to ensure that affected individuals will in fact have the ability to vote. That's why today I'm sending a letter to the governors in 3 of these states, Florida, Wisconsin, and Tennessee, asking them to inform the subcommittee of their plans for ensuring that the laws they have enacted will not disenfranchise the citizens of their state. Protecting the right of every citizen to vote and ensuring our elections are fair and transparent are not Democratic or Republican values. They're American values. Now I want to recognize my ranking member of the subcommittee, Senator Graham, for his opening statement.
Thank you, Mr. Chairman. Obviously, I have a different view on this. My state just passed a voter ID law, and I want to congratulate the legislature in South Carolina. In the future, if the Justice Department approves this program, you'll have to have a driver's license or a DMV ID card. And what we've done in South Carolina is if you don't have a driver's license, you can go to a Department of Transportation facility and get an ID card that will allow you to vote and do anything else you need an ID for, and we will give you a ride there. A passport, a military ID. We're going to come up with a voter registration card, which I think is a really good idea, that's going to be with a photo on it. You know, illegal immigration is something that bedevils the country, and the reason most people come here is to find work in America that they can't find in their native country because of corruption and lack of employment. So I understand why people come, but from an employer's point of view, it's hard to verify employment. So I, along with Senator Schumer, have suggested we take our Social Security cards and make them biometric, a photo, something that's tamper-proof, so when you get a job, the employer will know you are who you say you are. When you get on an airplane, you have to have some form of ID because we want to make sure that you are who you say you are because of the threats we face. And when it comes to voting, I don't think it's too much of a stretch to say you have to prove that you are who you say you are, and we'll find accommodating ways to get there. But I just have a different view. I think what South Carolina did makes eminent sense to me, and the law of the land, as I understand it, is the Indiana system's been upheld, and you will see more of this, Mr. Chairman, not less. 30 states have some form of voter ID requirement. So I think this is the future of the country, something we should embrace at the federal level because elections do matter. Casting a vote should be as easy as possible. It should require some participation. And I would end with this thought. Democracy is a fragile thing. We all have to work to make sure it survives. If you want to control illegal immigration, are you willing to do your part? Would you be willing to take your Social Security card, which can be duplicated by midnight as a piece of paper, and turn it into a biometric document to help the country secure employment? Are you willing to show your ID card to get on a plane just because we're threatened by people in the world and we need to know who they are? And all the hijackers had 5 or 6 fake driver's license. So I think sanctifying the voting process in a way that makes sense to make sure that we're electing people based on registered voters is a goal that we should all be concerned about, want to achieve. And from a South Carolina perspective, I have no desire to suppress people from voting. I want as many people as possible to vote and all of them to vote for me. And I know that's not realistic. And if you don't vote for me, that's okay. I want you to be able to vote, but I want you to make sure we do it in a way that preserves the integrity of elections, not just mine, but everyone else's. So thank you for the opportunity to speak.
Mr. Chairman, may I be recognized for a brief
Sure. Senator from
unanimous
Texas.
consent request and brief statement. I appreciate the chairman's consideration. Due to a conflict, I'm not going to be able to stay for the hearing, but I do have a statement. I'd ask unanimous consent be made part of the record, and speaks really to the voter ID issue that has been already previously discussed. But also, I'm glad that, to see Mr. von Spakovsky here, who I think is going to talk about the bipartisan legislation that we enacted last year. Senator Schumer and I were among the principal co-sponsors, enhancing the rights of military voters to vote absentee, and which resulted in some significant changes across state laws to facilitate, but we still have some challenges to meet. So with that, Mr. Chairman, thank you for allowing that brief statement.
Thank you, Senator Cornyn. Our first panel consists of colleagues from the Senate, and I see our colleague from the House, Congressman Gonzalez, who's welcome to join us at the table here as well. We'll get the proper nameplate up for you in just a moment. Our first witness is Senator Bill Nelson of Florida, currently serving his second term. He served as Florida's State Treasurer, Insurance Commissioner, and Fire Marshal, 6 terms in the U.S. House, 3 terms in the Florida State Legislature. Senator Nelson, the floor is yours.
Thank you, Mr. Chairman. And Senator Graham, the ID problem in my state of Florida is not a problem. We have a different problem. And it is simply not right when the laws are changed in a state to make it harder to vote. And that's what's happened in Florida. And of all places, if you'll recall the experience that we went through in 2000, when there were votes that were cast in error because of the construction of the ballot, when there were votes that were lost, when a lot of the military votes were either counted or not counted that didn't comply with the law, and there have been substantial changes there. It was a painful experience, and because of that, the state legislature set about on a series of reforms. They made it easier to vote, they made it easier to register to vote, and they made it easier that someone would have the confidence that their vote was going to be counted as they intended. That has suddenly been reversed in the state of Florida by the election law that has been passed and signed into law by the governor. In the first place, Mr. Chairman, what you mentioned, the League of Women Voters, which has been registering people as a civic project for decades, under law in Florida that had been on the books for decades, register a voter, you want to get those names turned in to the supervisor of elections in that county on a timely basis. They had 10 days. That's been on the books for years. It has now been constricted to 48 hours with the person obtaining the signatures and turning them in, subject to a fine of up to $1,000 if it's not turned in within 48 hours. Now, what is that intended to do? It ends up doing exactly what the League of Women Voters has done, and they have said they're not going to take the chance that their members are going to have those kind of fines. And therefore, an organization which was constantly over the years trying to get people to participate in our democracy by registering voters is not going to. All right, let me give you another example. Mr. Chairman, you talked about early voting. On the basis of the experience, the awful experience that we had in the presidential election of 2000, it was in a state particularly that has a lot of senior citizens, want to make it easier to vote. By the way, early voting, the supervisors of election love it because everybody doesn't pile in on one day, but they can spread that out. And we have had early voting for 2 weeks. But what did the legislature do? they constricted that back to 8 days. And they put the fiction that, the same number of hours of early voting are going to be as the previous law, because at the option of the supervisor of election that they can extend from 6 hours a day, they can go all the way up to 12 hours a day. But you know what? If they do, supervisors of election have to pay overtime pay. And what do you think has happened to the budgets of those statewide institutions, in this case, each supervisor in each of Florida's 67 counties? They're not going to be able to afford it. And therefore, the constriction of early voting has occurred. And, another interesting thing happened, Mr. Chairman. The early voting used to go up through the Sunday before the Tuesday election. That has been changed. It now will only go up through the Saturday before the Tuesday election. Does it cause anyone to suspicion that there is a certain number of voters on Sunday after church that go to vote? Again, cutting back on the people's opportunity to express their will through a free and fair ballot access process. And finally, I would point out another major change that the legislature made. We all have driver's licenses. In the state of Florida, they issue a driver's license, and it's probably as good for 5, 7, 10 years. So you don't go and change your address on your driver's license. If when you get to the polls and you have moved from one county in Florida to the other, and your identification does not match the registration when you moved into that new county, that new address, under the new Florida law, you will be issued a provisional ballot, not a regular ballot. Now, how many people innocently are going to get caught up in that because they didn't think to change the address on their driver's license? And by the way, what's the experience of provisional ballots? I would merely take you to the last presidential election, the 2008 presidential election in Florida. 1/2 of the provisional ballots, when attempted to be counted, were disqualified. Mr. Chairman, we ought to be encouraging people to vote and making it easier for them to register to vote, to have their vote counted as they're intended, and to be able to vote. This matter is hopefully going to be under judicial review. Organizations such as the League of Women Voters, I am told, intend to file suit in court. There are also some federal suits that are already in the courts. It's yet to be determined what the Department of Justice is going to do. Under the Voting Rights Act of 1965, there are still 5 counties on the watch list out of Florida's 67 that have to have pre-clearance with regard to the voting rights of those people being upheld. The Justice Department has already cleared those 5 counties with regard to non-controversial items. The question is, will they examine it, since the state of Florida did not appeal to the Justice Department on these controversial items of having your vote counted? Mr. Chairman, I certainly hope you will pick up this banner. And Senator Graham, you and I want the same thing at the end of the day. We want more people to vote, and we want them to be able to have that vote counted like they intended it. Thank you, Mr. Chairman.
Thanks, Senator Nelson. We appreciate you being here. Congressman Cleaver, come on up and join us here. We'll pull up a chair to the table. We're honored that you'd come across the rotunda and join us. I'd like to next introduce Senator Sherrod Brown, who's been a member of the Senate since January of 2007, served 7 terms in the House before, also 2 terms as Ohio Secretary of State, which is the chief election officer of the state, 4 terms in the Ohio General Assembly, and he taught at Ohio Public Schools and at the Ohio State University.
The Ohio State University.
Senator Brown.
I don't know why they say that, but they do, Mr. Chairman. So, thank you very much. It's a pleasure to be here, Ranking Member Senator Graham, Senator Frank, and thank you also for joining us. I'm pleased to sit with 2 of my former colleagues in the House, Charlie Gonzalez and Emmanuel Cleaver, both leaders in many ways, and especially on voting issues, and I appreciate the work that they do. I testify, as Chairman Durbin said, not only as a senator of a state often at the center of our national elections. I testify as an 8-year, 2-term former Secretary of State of Ohio charged with administering those elections from 1983 to 1990. You remember in my re-election in 1990, my then 6-year-old daughter, the election I actually lost running against a fellow by the name of Bob Taft, and my daughter, who was 6, one day we're getting out of the car and she said, "Dad, let me make sure I understand now, you count the votes in this election." I said, "Yeah." And she said, "Well, what's the problem?" Didn't work out quite so well. She's become a bit more cynical since then, Mr. Chairman. So I understand the burdens of the costs and resources in ensuring the fundamental right to vote's exercised. Inherent in that responsibility is ensuring that voting is accessible and free of intimidation and roadblocks. As a state, over a period of decades, Ohio's legislators undertook a bipartisan, I would underline, bipartisan effort to help Ohioans vote more easily. When I was Secretary of State, we had major assistance and input from Republicans as we made voting laws work for huge numbers of people. As Secretary of State, I asked and people cooperate, utility companies cooperated by including voter registration forms in utility bills. Driver's license bureaus registered people to vote. Various social service agencies, various local businesses. And one company housed in the chairman's state, McDonald's Corporation, at our request printed 1 million tray liners that were put in McDonald's restaurants all over my state that people could register to vote on their tray liner. So that occasionally someone turned in registration forms with ketchup and mustard stains, but accepted by, and still, I assume some of them are still in boards of elections around the state. We made, and that was bipartisan in those days, but rather than protecting the right to vote, we're seeing brazen attempts around the country to undermine it. Today, there's a concentrated campaign sweeping the nation and far too many state legislatures across the country. Texas, Florida, Ohio, 3 of the most notable, undercutting the very protections that I believe are enshrined in our Constitution and the Voting Rights Act of 1965. These new state voting laws are a result of an organized effort to limit voting rights. It does so in 3 primary ways. It implements strict voter ID laws that require showing limited forms of voter ID before voting. Ohio legislature, I will get to a specific Ohio in a moment, has decided to sort of bifurcate their efforts. One of their proposals, which has not yet become law but might this month, doesn't allow state university IDs to count, for instance. So it's restrictive in many ways that I think don't make much sense. The second, it significantly reduces early voting or the availability of absentee ballots, as Senator Nelson pointed out in Florida, and it limits voter registration efforts. This hearing will examine several of these laws and what I think is an ideological campaign underpinning them. I'll focus on Ohio for a moment. During the 2004 presidential election, Ohio saw, in some sense, a bit of a rerun of Florida 2000. A dysfunctional election marred by electronic voting machines improperly tallying votes and Ohioans waiting in line for as long as 9 hours. I was at Oberlin College then in my congressional district where young voters waited for 6 hours to vote. Kenyon College, just an hour south, not far from where I grew up, voters waited 9 hours to vote. This wasn't a question of voter fraud, of individuals trying to game the system. This was a question of an individual voting multiple times. voters aren't going to try to do that. There's nothing in it for a voter to try to vote 5 times and change an election. The problems are elsewhere, but not by the voters. The clouds over the 2004 election in Ohio were all caused by process, not by individual voters. Now, 7 years later, after we were a national model, what the Republican and Democratic members of the legislature did, and what I try to do administratively as Secretary of State, partnering with all kinds of people and businesses, that national model is Ohio's poised to return to the headlines, again, for the wrong reasons. The new election law, which is signed into law by Governor Kasich, it may be subject to a ballot challenge, so it may not take effect yet. Does little to fix the problems of the process. It only exacerbates it. Among the most pernicious elements, again, this is a repeal of legislation that mostly a Republican legislature and a Republican governor enacted in the decade before, since I was there, but in the early part of the 21st century. So there was consensus, and that's what's disturbing. There was consensus in America about voting rights, and there was consensus in Ohio about what works best. Changes at the margin, but now there's a direct attack undermining so much of what I thought we all believed in this country. This new law in Ohio shortens significantly the early voting window. It eliminates, as it does in Florida, you can see this pattern, early voting on the Saturday, Sunday, and Monday prior to the election, the 3 busiest days of early voting. I know that eliminating, as Senator Nelson said, limiting early voting ultimately costs more money. The election system, the administrators in Ohio, very bipartisan, equal number of Republicans and Democrats. That's our state law working in boards of elections. They like it this way because it spreads out the sort of bursting chaos of an election, and it saves money ultimately for the election system. Parents with children in tow, shift workers heading to work, busy professionals who have trouble. It's not so hard for us, but a single parent taking a child that's got a kid in tow and has got to get home and fix dinner, they have to stand in line on election day for 2 or 3 hours. Some of them go home. Of course they do, because the most important thing in their life is their kid and feeding their kid and getting ready for school and doing all the things that people do in their regular lives. Ohio's new law also prevents counties from mailing absentee ballots to eligible voters. There was an agreement, which I'm heartened by, between the Democratic County Executive in Cuyahoga, our state's largest county, and the Republican Secretary of State, who has frankly been much more reasonable about all these reforms than some of his former colleagues, when he was Speaker of the House and the legislature. They have worked out some arrangements and some agreements there that will make this a little bit better. The absurdity of this bill, Mr. Chairman, in part, is that it prevents poll workers from even by law, even in assisting some voters when they're asking questions when they come in. I mean, how absurd is that? Any fraud is too much, but proposed voter ID solutions are worse than the cure. In Indiana, more nuns were banned from voting because as elderly residents of their convent, they didn't have photo IDs. Then there are cases of documented voter fraud in the state. Yet the conservative Roberts Court watered down voting rights in Crawford versus the Marion County Board of Elections, even with the unproven basis of voter fraud. Although most Americans have government-issued photo ID, as Senator Graham suggested, studies as recently as May of this year show that as many as 11% of eligible voters nationwide do not. If they can't find a birth certificate, can they get a government-issued ID in Ohio? Not clear. Who pays the $10 for the voter ID? Why do we put this burden on people that have voted religiously and regularly for year after year after year, and do many of them just give up? Perhaps some in the legislature hope they do, but it's not good for our country. If this law were to pass in my home state, nearly 890,000 Ohioans over age 18, 890,000 Ohioans over 18 who lack driver's license could be disfranchised. This includes especially the elderly, especially people in rural communities, and a number of Ohioans on college campuses. Proponents assert that voter fraud is prevalent and needs to be addressed by sweeping elections reforms. In 2002 and 2004 Ohio elections, there were only four instances of ineligible individuals voting or attempting to vote out of 9 million voters in those 2 elections. That's a 0.00004% of voters. The nationally renowned bipartisan Brennan Center said the numbers are so staggeringly small that an individual has a better chance of being killed by lightning than the chance of an individual impersonating another at the polls. That sort of says it all. Mr. Chairman, I'll conclude with just saying this was consensus in our country until a group of radical proposals came in my legislature and other legislatures across the country. And in a nutshell, this is a solution in search of a problem. It's not something we need to do. The voting system has worked in this country. It's gotten increasingly better from the days of the 1957 Civil Rights Act to the 64 Civil Rights Act to the 65 Voting Rights Act. We know that we made progress in this country. Why should we go back? It really is a solution in search of a problem. Thank you, Mr. Chairman.
Thank you very much, Senator Brown. Congressman Rokita, thank you for joining us. And we're going to find a seat for you at the table here as quickly as our staff can slide a chair over. In fact, Senator Brown's chair, all warmed up. Next up is Congressman Charles Gonzalez, serving your 7th term, representing the 20th Congressional District of Texas and chairman of the Congressional Hispanic Caucus. Prior to service in Congress, Representative Gonzalez was a Texas state court judge for more than a decade and a lawyer in private practice for 10 years. Thanks for coming across the rotunda, joining us today. Congressman Gonzalez.
Thank you, and Chairman Durbin, Ranking Member Graham, and of course Senator Franken as member of the subcommittee. Thank you very much for this opportunity to testify about a very troubling trend that is occurring in many of our states. We have seen a consolidated effort by states across the country to enact laws which will deny thousands, if not millions, of Americans of the constitutionally protected right to vote. While I will be speaking chiefly about the impact of Texas's new law, the same effects will be seen in many other states, since these laws have been linked to the model bill of a single partisan group seeking political advantage at any cost. Texas holds biannual legislative sessions, which means few surprises. Yet, Governor Perry declared voter ID a legislative emergency, calling it necessary to combat rampant voter fraud. Now, that's a common claim, but it's made without a shred of evidence. We've all heard stories of dead people voting, but when they're investigated, we find them alive and, well, quite a bit surprised. I'd refer you to some cases, but I can't, because even the Texas Attorney General, in 2006, in his press release, which was entitled, "Let's Stamp Out Vote Fraud in Texas," couldn't name a single case of fraud that would have been stopped by voter ID. The law stops no actual problem. It just creates a burden that state and local governments will struggle to meet in spite of millions of federal dollars in EAC grants, the very commission that is attempting to be eliminated on the House side. Now, those localities and states are going to need it. The list of acceptable forms of ID is so short that not even an ID from the Veterans Administration will be accepted in the state of Texas. Your Senate ID won't count. My House of Representatives voting card with my identification, my picture won't count. The most common ID is a driver's license, but 30 to 40% of Texas voters don't have one. So DPS, the Department of Public Safety, will have to handle hundreds of thousands of applications in just 35 days as this law takes effect and we have a March 6 primary, including weekends and holidays when the offices will be presumably closed. The state legislature provided $0 to handle the influx. They have no plans for special lines, extra staffing, or extended hours. Tens of thousands of Texans live more than 100 miles from the nearest Department of Motor Vehicles, because in Texas, 100 miles is not that far. But if you're elderly and have a hard time getting around, or if you're a minority and can't take time off from work, it is a problem. And the wait at one San Antonio Department of Motor Vehicle office was nearly 90 minutes. This will not be a smooth process. The Department of Motor Vehicles will mail the applications to the Department of Public Safety headquarters in Austin, Texas. The current turnaround time is 2 weeks, but no one knows how the flood of new applications will slow the process. Voters who can't get their ID in time or forget to bring it to the polls will have to vote provisionally at an average of 22 minutes per vote, because I've already met with my election officials. That's how long it's going to take. So what does that mean? More poll workers, longer lines, and in neighborhoods like in the west side of San Antonio, where voting can already take hours, this will only further discourage participation. Now, I don't even want to tell you about the cure time. Once you vote provisionally, you've got 6 days after the election to go to the main headquarters downtown, pay $6 to $10 parking if you have a car, and you can get there. You didn't have a driver's license, so there's a good chance that you don't have a car. Members of Congress can take work, right? We can take time off from work to get an ID or even go to vote. But few working people have such flexibility. Once again, those already bearing the hardest and harshest burdens will be asked to take on the most. Of even more concern is the fact that these laws are not always enforced evenly, and that is an experience not just in Texas. My written testimony includes a few horror stories about how poor and minority voters already face more challenges at the polls than wealthy and white voters. We must each draw our own conclusions about who benefits when poor and minority voters are disenfranchised. Since the founding of our country, constitutional amendments and laws have opened the voting process to minorities, women, and young citizens that we send into combat. In recent years, early voting and no excuse absentee ballots have increased turnout and civic engagement. Yet Texas and other states are reversing this trend and curtailing the availability of both, driving hundreds of thousands of voters from the polls and creating a more disengaged citizenry. You have heard this often from our Republican colleagues. When we tax something, we get less of it. So it'll be no surprise if these de facto taxes on voters' time and money drive down turnout. Voter ID laws don't stop fraud. They just suppress voting. The recently enacted Texas photo ID law is a prime example. In the more serious examples of electoral fraud, it is not the voter who is at fault or perpetrating the fraud, but political operatives or corrupt government officials. And voter ID laws will not stop them. But voter ID laws do have a disparate impact on the poor, the young, the elderly, and the disabled. And these groups are disproportionately minorities. And however much progress we have made, disparate treatment and discrimination against minorities remains a serious problem. We have made great progress in the past 235 years, tearing down barriers that disenfranchised millions of Americans. We must not return to those dark days of the past. Thank you again.
Thank you very much, Congressman Gonzalez. Congressman Emanuel Cleaver from Kansas City, Missouri, is now serving his fourth term representing Missouri's 5th Congressional District. He is chairman of the Congressional Black Caucus and previously served as a mayor and member of the City Council of Kansas City. Congressman Cleaver, please proceed with your testimony.
Thank you, Chairman Durbin and Ranking Member Graham. I appreciate the opportunity to appear before you today on one of the most significant civil rights issues of this moment. I'm pleased to be the chair of the Congressional Black Caucus during the 112th Congress and during the 40th anniversary of the CBC. On behalf of our membership, I can say that the issues surrounding voter suppression are particularly troubling to us. Many of us come from families who fought diligently to earn the right to vote, so it is a moral imperative for the members of the CBC to fight to protect the right to vote for all Americans. The Congressional Black Caucus was founded by and is often referred to as the conscience of the Congress. Today, I am before you to express my steadfast commitment to protect the gains we have made throughout history. I'm also here to express the deep and abiding concern the CBC has with this year's onslaught of voter suppression laws, which have not so ironically arrived in time for the 2012 elections. It is also not ironic that early voting days have been cut short, stiffer identification requirements have been implemented, and proof of citizenship required, all statistically proven to impact people of color disproportionately. I regret that as the Martin Luther King Jr. Memorial was recently unveiled in our nation's capital, I'm here today to put you on notice that we are still fighting the battle to protect the right to vote, one of the causes Dr. King died for and reminiscent of the 1960s. Additionally, we can appreciate the significance every time we see our colleague, John Lewis. As you all know, Congressman Lewis is not only a proud member of the Congressional Black Caucus, he is also a civil rights icon amongst us. My good friend, Congressman Lewis, nearly gave his life to protect our rights. He was a leader with the Southern Christian Leadership Conference President Martin Luther King in a peaceful march across the Edmund Pettus Bridge in Mississippi, in Alabama, so that you and I could cast our votes. In fact, that bloody Sunday helped hasten the passage of the Voting Rights Act of 1965. Mr. Chairman, John Lewis could not be here. He is in Georgia on a family emergency, and I would like to introduce Congressman Lewis's op-ed in the New York Times, August 26th, as part of the record, as well as a brief by the National Association for the Advancement of Colored People.
Without objection, they'll both be made part of the permanent record.
Given the disproportionate impact the voter suppression laws will have on African American voters, these laws are reminiscent of the poll taxes used in the Jim Crow South. The laws are solutions in search of problems, especially when it comes to voter ID, because there is basically no evidence of voter fraud. Requiring voters to provide a specifically narrowly defined piece of photo identification is unnecessary. The safeguards currently in place to verify voters' identity actually works. That much is clear because there has been no evidence of substantial voter impersonation fraud. The only type of fraud requiring voters to provide a specific type of government-issued ID guards against it. Now, Mr. Chairman, the fraud often used by proponents turns out not to be fraud at all. Absentee ballot fraud, felons voting, and other issues are not solved, as my colleague said, by requiring voter ID. And the 23 states and the District of Columbia now allows voters to show both photo and non-photo IDs, such as a utility bill or a bank statement. After the Reconstruction era ended in 1877, African Americans ceased to hold significant political power in the South. In the 1890s, the Populist Party attempted to merge the common economic interests of poor African American and white farmers. The elite party in the South at the time, the Democratic Party, wanted to retain their power, so they worked diligently to disenfranchise African Americans to ensure their continuity of power. I'm doing some family research. I was born and raised in Texas and had the great pleasure of growing up with two great-grandfathers. One of them, Noah Albert Cleaver, who died at the age of 103. I was married with children. We've not been able to find any proof that Grandpa ever voted. In the state of Texas, during most of his life, Grandpa had to pass a literacy test in Texas. An example of the questions: how many seeds are in a watermelon? How many bubbles are in a bar of soap? That's what Grandpa faced. To vote, African Americans had to pay $3.50 in the state of Texas, Ellis County, Waxahachie, Texas. Grandpa, in all likelihood, lived in this country 103 years and never voted. He's not alone. There are many others who are in the same situation. I believe we have a modern-day poll tax. There is a cost for state ID in every single state in the United States. My father, now 89 years old, has no idea his birthday. My grandma, Grandma Annie Mae, his mother, had two sons born in the month of July. One on the 15th, one on the 27th. She couldn't remember which one. African Americans were not allowed to go to hospitals at that time. So when my father and his older brother became teenagers, they just decided to choose a day. You celebrate this day, I'll celebrate this day. And they've done it all of their lives. My father is 89 years old in perfect health, still drives. But what happens if my father did not have a driver's license? He has no birth certificate. No birth certificate. He was born in Grandpa's house in the kitchen. Why in the world are we doing things to make voting more difficult? It would seem to me in the United States of America, in the 21st century, we would do everything conceivably possible to give everybody encouragement to vote. We're encouraging democracy in Iraq. Let's demand it at home and do away with anything that prevents any American from voting. Thank you, Mr. Chairman. I appreciate the opportunity to be before you.
Congressman Cleaver, thank you very much. We're honored to have Representative Todd Rokita here. He's serving his first term representing Indiana's 4th Congressional District. Like Senator Brown before him, prior to his service in Congress, Congressman Rokita served 2 terms as the Indiana Secretary of State. During his tenure, he was president of the National Association of Secretaries of State. Congressman Rokita, the floor is yours.
Thank you, Mr. Chairman. I'm pleased to know that as I visit here from the other side of the rotunda, you all don't take as much adherence to the time clock as we do on our side. In light of that, I won't be more than 40 minutes or so. Chairman Durbin.
Don't push your luck.
Chairman Durbin, Ranking Member Graham, and members of the committee, thank you for the opportunity to share my experiences with Indiana's photo ID law. In light of the last bit of testimony, I'd like to indeed bring us back to the 21st century. As you may know, I was the Secretary of State of Indiana for 8 years, from 2003 to 2010, prior to coming here. And as Secretary of State, I was also the Chief Election Officer when Indiana's photo ID law was created, and I helped draft that specific bill with my state legislators. It became law, and then I had to oversee the legal challenges that followed, as well as implementing the law. Governor Daniels signed Indiana's voter ID law in the spring of 2005. Indiana's law requires that to vote in person, a voter must present a valid photo ID issued by Indiana or the United States. That ID must have a photo of the voter and the expiration date. I imagine, as I listened to Representative Gonzalez's testimony, that to the extent one of those photo IDs examples that he mentioned didn't comply with the Texas law was because it didn't have an expiration date. And there's a very logical reason why we have an expiration date on these in our law, and that was because people's facial images change. I mean, they get older, for example. Now, it wasn't that our law was so strict.
I'm not sure a senator or congressman. The same photo will last for decades.
I've forgotten where I am. Thank you, sir. It's not that we were so strict in Indiana as to say, well, the photo IDs had an expiration date of yesterday and today's election day, therefore you can't vote. I mean, that's an example that I would agree with these gentlemen on. That would be unreasonable. Our face doesn't change that much in a day. So as an example of the reasonableness in Indiana's law, we simply said, all right, you can vote on an expired ID up to 2 years. So we did things like that all along the way to accommodate the arguments that I'm, again, hearing today, but certainly we haven't heard for the first time. And the bottom line is Indiana's, after 6 years worth of elections, Indiana's photo ID law works. In fact, people that agree with the comments that I've heard already have been looking. They have looked. I think they've given up looking finally for problems with Indiana's photo ID law. We have not been sued once. We haven't even had allegations, legitimate allegations, that anyone, Hispanic, black, woman, man, young, old, whoever, has been legitimately or illegitimately disenfranchised by Indiana's law because it's reasonable. It's reasonable also because whether or not you agree that in-person voter fraud exists, and I will say that as 8 years being Indiana Secretary of State, it does exist. We have allegations made every election. That doesn't mean I'm trying to denigrate Hoosiers. We are some of the, I think, most reasonable, common sense, God-loving, patriotic people that this nation knows. But if it's happening in Indiana, it's happening everywhere, from New York to California. Now, these gentlemen and others say, well, you can't produce one case. You can't produce one conviction. Therefore, it doesn't exist. The word evidence was used. Well, that's not true. There's a lot of evidence. And there are several cases that I've presented to prosecutors who haven't taken up the case. Not because of a lack of evidence, but because think about the kind of fraud it is. Think about the kind of crime it is. It's something that happens in an instant, and then it's gone. The witnesses dissipate. These are volunteer poll workers. It's not a domestic violence case. It's not something that leaves visible scars or blemishes or bruises. And so it's a kind of a case, it's a kind of fraud that's very hard to prosecute. But that doesn't mean it doesn't exist. And the bottom line, it's not a matter of how many cases or convictions there are, gentlemen. It's a matter of confidence. In a free republic, you have got to have the personal responsibility to participate. Voting is one of the highest and best civic transactions we can undertake. I've heard today that people have to leave their jobs to come and vote. Why make it harder? Well, I would take the opposite end of that. People leave their jobs, they leave their work, sometimes they leave their kids to go vote. Hopefully they take their kids with them. Hopefully they wait in a short line as they do in Indiana. We haven't seen extended long lines in Indiana after 6 years at all. It hasn't elongated the voting process. But you leave your day-to-day life to come vote. And then you get to the poll clerk, you sign in, maybe, and you realize that the perception is that the people that are doing this process don't take it nearly as seriously as some of the other transactions that they partake in day-to-day life. And so I would argue it leaves the perception of a lack of confidence. These people didn't even care enough to find out who I was, yet they asked me to leave my life and go vote. We want to instill confidence in the process to drive up turnout. And in fact, in Indiana, since we've had the photo ID law, voting turnout has gone up 2%. It wasn't enacted to increase voter turnout, wasn't enacted to decrease voter turnout. But the effect was it has increased voter turnout. If you do it the right way, if you do it reasonably, you will instill confidence in our process, which is definitely needed, definitely a prerequisite to having a successful free republic and to allow this citizenry to participate and to grow the personal responsibility that is needed if we are going to maintain a free republic. So with that, thank you for letting me come this afternoon, and I'd like to enter my remarks for the record.
Thank you, Congressman Rokita, and of course your remarks in their entirety will be part of the record, and the remaining 35 minutes that you were going to take will be published instead of transcribed. I don't know if there are any questions of our guests from the House. If not, we're going to go to the second panel. We thank you very much for coming. I know Senator Graham has to go to another meeting, but thank you for joining us this morning, or this afternoon. We're going to turn to our second panel of witnesses, and I'll ask the witnesses to take their places at the table. Each witness is going to have 5 minutes as an opening statement, and their written statements will be included in the record. They include Judith Brown Deannis, I hope I pronounced that correctly, Hans von Spakovsky, and Justin Levitt. And if they would please stand for just a moment, please. We have a tradition of administering an oath to our lay witnesses. If you please raise your right hand, do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, nothing but the truth, so help you God? Let the record reflect that all three witnesses have answered in the affirmative. Our first witness is Judith Brown Deannis, co-director of the Advancement Project. Previously was an attorney with the NAACP Legal Defense and Educational Fund. Ms. Brown Deannis graduated from Columbia University School of Law, was a recipient of the Skadden Fellowship. Ms. Brown Deannis, the floor is yours.
Thank you, Chairman Durbin, for inviting me to testify about new voting barriers. I respectfully request permission to enter my entire written testimony into the record.
Without objection.
I am a civil rights litigator and co-director at Advancement Project, a national civil rights organization. Since 2000, we have worked with local civic engagement groups and election officials to eliminate barriers to voting. Our country has not seen such widespread attempts to disenfranchise voters as we have seen this year in more than a century. Inclusive democracy is under attack. New barriers to voting may neutralize recent surges in Black, Latino, and youth voter registration rates and record voter turnout. These laws may systemically disenfranchise already registered voters in these groups, as well as limit voting of people who are poor, people who are elderly, and people with disabilities. The new barriers to voting include laws that place restrictions on the number and type of acceptable voter identification introduced in 34 states this year, laws to limit early voting, such as bills passed in Ohio, Tennessee, Georgia, West Virginia, and in Florida, where 30% of voters cast early ballots in 2008, with twice as many African Americans doing so than whites. Laws that place restrictions on nonpartisan voter registration efforts, such as that in Florida. African Americans and Latinos are more than twice as likely as white voters to register through voter registration drives. Laws such as that passed in Kansas and Alabama requiring documentary proof of citizenship to register. Policies such as those in Florida, Iowa, and Virginia making it harder for people with criminal records to regain their voting rights even after they've paid their debt to society. And lastly, reactionaries have announced plans to place millions of challengers at the polls in 2012 to challenge voter eligibility in ways that may intimidate voters and disrupt polling place operations. Of all the barriers, the most pervasive new threat to voting rights has been voter identification restrictions. The issue is less about whether voters should be made to demonstrate their identity at the polls, but rather how restrictive the forms of identification should be. Election officials realize these laws are budget busters, have gone too far, and will create election administration nightmares. As Ohio Republican Secretary of State John Husted, splitting from party ranks, explained, quote, "I believe that if you have a government-issued check, a utility bill in your name with your address on it, that no one made that up. They didn't establish utilities in their name to commit voter fraud. Let's be clear about this. There are some other forms that are legitimate. What if I lose my ID on Election Day? Should there be no other alternative I can use to cast my ballot? I think there should be," close quotes. In a trial run in Wisconsin on voter ID, the Madison County clerk explains, quote, "Between showing ID and signing the poll book, the amount of time each voter needs to spend at the poll book has at least doubled. The minimum number of election officials needed at each polling place will increase from 5 to 9. Election officials are very concerned about dealing with voter lines that could easily become 2 or 3 hours long," close quotes. Further implementing photo ID laws could cost cash-strapped states $20 million or more. Despite the myth that everyone has ID, many voters do not. In South Carolina, 178,000 registered voters lack a driver's license or state identification. In Wisconsin, 23% of voters aged 65 and older lack state ID. Among young voters, 18 to 24, 78% of African American men, 66% of African American women, 59% of Latino men and 46% of Latina women in Wisconsin lack the ID. The IDs are also hard to get. Nora Elise, 88, in Georgia, was told she needed to produce her 1946 marriage license to show her name change to get an ID. She fears she won't be able to vote because of the difficulty of getting her marriage license. In Missouri, we represent Emmanuel Aziz in a lawsuit challenging the ballot initiative that, if passed, would require state-issued photo ID. Mr. Aziz is a registered voter with an expired driver's license and passport, which lapsed during his illness with multiple sclerosis. He's confined to a wheelchair. It will be nearly insurmountable for him to get renewed his license due to a lack of transportation and inability to pay for the supporting documents. The difficulty of obtaining ID is exacerbated further by budget cuts that have led to the closure and reduced hours of offices where IDs and underlying documents may be obtained. In Wisconsin, DMV offices are closed on weekends, and 25% of offices open less than 1 month a day. Similarly, in Texas, approximately 500,000 Latinos and blacks live in counties without ready access to Department of Public Safety offices in their counties. 80 counties have no office or closed it altogether. In Tennessee, only a third of the counties have DMV offices, and those in urban areas, serving predominantly people of color, have wait times up to 4 hours. Furthermore, the ID of would-be voters must pay first for obtaining the underlying documents, which is a certified birth certificate, etc., making these laws effectively poll taxes. In Texas, it would cost you $22 for a birth certificate, and a passport can cost up to $145. Thus, one must pay to vote. These new laws represent the largest legislative effort to roll back voting rights since post-Reconstruction era. Collectively, they effectuate a trifecta of voter suppression, making it harder to register to vote, harder to cast a ballot, and harder to have a vote counted. And the impact is not evenly distributed, and indeed is designed to effectuate political results. Americans should be outraged that across the country, efforts are being undertaken to make voting harder and to silence some. After all, Election Day is the one great equalizer. Regardless of race, gender, religion, disability, or income, we all have the same amount of power when we go into the voting booth. That is what makes this nation great. We cannot go backwards. Thank you.
Thank you very much. Our next witness is Hans von Spakovsky, Senior Legal Fellow at the Heritage Foundation Center for Legal and Judicial Studies. He's also the manager of the Heritage's Civil Justice Reform Initiative. Before this, Mr. von Spakovsky served 2 years as a member of the Federal Election Commission. Prior to that, he worked at the Justice Department as counsel to the Assistant Attorney General for Civil Rights. He's also served on the Board of Advisors of the U.S. Election Assistance Commission and on the Fulton County, Georgia Board of Registrations and Elections. He's a member of the Fairfax County, Virginia Electoral Board and the Virginia Advisory Board to the U.S. Commission on Civil Rights. He obtained his law degree from Vanderbilt University School of Law and his bachelor's degree from Massachusetts Institute of Technology. Mr. von Spakovsky, thank you for joining us, and please proceed. If you'd like to repeat the compliment, go ahead.
Is it on now? Okay. Thank you, Senator Durbin. As we prepare for the 2012 election, it's critically important that states approve the security and integrity of our elections. One of the key principles in any fair election is ensuring that the person who casts a ballot is legally eligible to vote. The fairest way to do that is by requiring individuals to authenticate their citizenship when they register and their identity when they vote. Such measures also increase public confidence. As Governor Lincoln Chafee, an independent, said when he signed Rhode Island's new voter ID law sponsored by Democratic state legislators, requiring ID at the polling place is a reasonable request to ensure the accuracy and integrity of our elections. The evidence from numerous academic studies and actual turnout in elections is overwhelming that, contrary to the claims of opponents, voter ID does not depress the turnout of voters. In fact, a study by the University of Delaware and the University of Nebraska that looked at turnout across the country said that concerns about voter ID laws affecting turnout are much ado about nothing. Voter fraud exists, and criminal penalties imposed after the fact are insufficient deterrent. When Justice John Paul Stevens wrote the majority opinion of the U.S. Supreme Court upholding Indiana's voter ID law, he noted that examples of such fraud have been documented throughout this nation's history by respected historians and journalists, and not only is the risk of voter fraud real, but it could affect the outcome of a close election. African-American Senator Harold Metz, who co-sponsored Rhode Island's law, noted that very few adults lack one of the forms of ID that will be accepted, and the rare person who does can get a free voter ID card, and that he would not have supported any obstacle to voting. Polls show overwhelming support for voter ID across all ethnic, racial, and party lines. That's no doubt because Americans have to use a photo ID to obtain a library card, drink a beer, cash a check, board an airplane, or check into a hotel. Those in the leadership of organizations opposed to such common sense reforms are clearly not in touch with their constituents. Actual election results confirm voter ID does not hurt minority turnout. Voting in both Georgia and Indiana increased more dramatically in 2008 in the first presidential elections held after their photo ID laws went into effect than in some states without photo ID. There was also an increase of over 7 percentage points in the turnout of registered black Georgians from the 2006 to the 2010 midterm congressional elections. The Georgia voter ID requirement was upheld in state and federal court, including the 11th Circuit Court of Appeals and the Georgia Supreme Court. They held that such ID requirements are not discriminatory, do not violate the Constitution or any federal voting rights laws. After years of litigation, none of the plaintiffs, including the NAACP, could produce a single individual who did not have a photo ID or could not easily obtain one. In Indiana, the turnout of Democratic voters in 2008 increased by over 8 percentage points from 2004, the largest increase in Democratic turnout of any state in the nation. According to the census, there was a 5% increase in the turnout of the black voting age population in the 2008 election compared to 2004. Black turnout in Indiana in 2010 was even higher than black turnout in the 2008 election, which was a banner year for black turnout. The evidence is indisputable also that aliens are registering and voting. In 2005, the GAO issued a report finding that up to 3% of the 30,000 individuals called for jury duty from voter registration rolls in just one U.S. district court were not U.S. citizens. I recently received an order from a 2010 immigration case in Orlando, Florida, of a Cuban immigrant who arrived in Florida in April of 2004 and then promptly registered and voted illegally in the November election. The only Americans really being disenfranchised as a large group today are overseas military voters. Only an anemic 4.6% of them cast an absentee ballot that was counted in the 2010 election, and that's something that does need to be taken care of. 3 more quick points. The ability to travel freely within the U.S. is a basic right. Yet there's been no claims that the federal requirement to show a photo ID before boarding a plane is somehow discriminatory. No one can enter most federal buildings to exercise the First Amendment right to petition the government without a photo ID, yet there have been no cries that this is Jim Crow. The right to work is just as important as the right to vote. Yet federal law passed by this Congress mandates that no one can be employed without producing documentation authenticating their identity and U.S. citizenship or legal authorization to work. There's no claims that this federal requirement is Jim Crow. States are simply implementing a similar requirement to authenticate identity and citizenship for voting. As Rhode Island Democratic State Representative John Bryan said, voting is one of the most important rights and duties we have as Americans, and it should be treated accordingly. Thank you.
Thank you very much. Justin Levitt is our next and final witness on this panel, Associate Professor of Law at Loyola Law School in Los Angeles, previously counsel at the Brennan Center for Justice at NYU Law School, served in various capacities for several presidential campaigns, including the National Voter Protection Council in 2008, graduated magna cum laude with a law degree and master's degree in public administration from Harvard, where he was an articles editor for the Harvard Law Review, also earned a bachelor's degree magna cum laude from Harvard College. Professor Levitt, thank you for coming all the way from Los Angeles.
Thank you very much, Mr. Chairman. Thank you for having me here. Mr. Chairman, Senator Franken, and thank you as well for entering the full written testimony that I've submitted to you into the record. I very much appreciate that. I am a constitutional law and election law scholar at Loyola Law School in Los Angeles. My scholarship is based on careful research into the very real-world costs and benefits of election policies. I think it's very important to have a grounding in the real facts, and so I appreciate this opportunity to share some of them with you here today. Unfortunately, 2011 has seen several states ignoring this balance, careful balance of costs and benefits, imposing real burdens on real Americans without real reasons. There are several categories of these new laws. I'd like to take just a few moments of my opening statement to address 3. First, voter registration. We've heard a lot about this today. The biggest cutback is in Florida, again. In 2005, Florida law shut down registration drives for the League of Women Voters for the first time in its 67-year Florida history. That law was struck down in court. Now the restrictions are back. The new law requires citizens to get government permission before they touch a voter registration form from anyone other than their immediate family. This stops impromptu drives at bake sales, churches, and at actual tea parties. In the campaign finance arena, conservative groups have vigorously challenged far less burdensome restrictions. These new restrictions limit participation far more than necessary to ensure that the voter registration process is both clean and smooth. Second, early voting. We've also heard about this today. Florida has also cut back here. The most significant cut the Sunday before Election Day. On this Sunday, particularly in minority communities, and vastly disproportionately in minority communities, citizens who work long hours during the week, go to the polls after church, fulfilling their civic obligations after their spiritual ones. Cutting this Sunday, in particular, makes no sense. That is, there's no justification for it at all. In Florida, each county could choose to offer voting on the final Sunday or not. Where it cost too much, counties declined. But 10 counties opened the polls on that final Sunday because they thought they could better and more efficiently serve their constituents. As Senator Nelson said, as Senator Brown said, for no good reason, the state now limits their options and increases their costs by mandating that they close shop on that final Sunday when people are coming from church. Finally, I'd like to mention new restrictive ID laws. I've devoted extensive space to this in my written remarks, in part because there's so much myth and misinformation out there, and I hope there's time to clarify in further questions if you have any. At the moment, 6 states stop citizens from casting a valid ballot at the polls if they do not have particular types of government-issued photo ID. They're the minority. All states have some process to make sure that people are who they say they are before they vote. The other 44 states offer options because they know there are real, live, eligible American citizens out there who simply do not have the ID required in the most restrictive states. I give specific examples of specific names of these real, live, eligible people in my written testimony. There are many more. Voting is a right for them, too. Now, everyone agrees that most citizens have photo ID. There's no dispute there. But a substantial number don't. And they have constitutional rights as well. It's tough to know exactly how many don't. There are good scientific studies and bad scientific studies. Unfortunately, I think Mr. von Spakovsky's numbers would fail Statistics 101 at just about any college in the country. The best way to know who doesn't have the right ID is to ask them. And when you ask them, between 2, for the most conservative estimates, and 20 million, between 2 million and 20 million American voting-age citizens raise their hands. They're disproportionately minorities, disproportionately poor, disproportionately young, disproportionately seniors. And if you don't have ID, it turns out that it's awfully tough to get ID. There's no good reason to close out these millions of people. As Senator Brown mentioned, Americans are killed by lightning more often than they're victimized by any sort of fraud that ID stops. Representative Rokita mentioned allegations of in-person impersonation fraud in Indiana. I'd love to hear them. I haven't yet seen any reports of any in-person impersonation fraud in Indiana, and I'm not talking about prosecutions. Allegations. We think there's been a problem. In fact, at the largest stage in the country, at the Supreme Court, there were a total of 9 alleged votes nationwide since 2000 that might, if they were fraud at all, have been stopped by ID. 9. There have already been many more than 9 real Americans blocked by the new ID restrictions. Indiana's law does work, but it works to keep people from voting a valid ballot. And there have already been elections, including a school board election in 2010, decided by provisional ballots cast by individuals who didn't have ID and couldn't prove, using Indiana's new restrictive law, that they were who they say they were. We've amputated a foot to cure a potential hangnail. One word on airplanes. Mr. von Spakovsky is fond of saying that you need photo ID to board a plane. I wish he'd add, and I'm George Clooney, because neither one is true. To get to you today, I had to board a plane from Los Angeles. I never showed photo ID. While waiting in the terminal, I drank a beer while waiting for the flight and quite enjoyed it. I never showed ID. To come testify before you today, I had to walk right in through this federal building and never showed ID. In fact, I haven't had photo ID in my wallet the entire week. Airlines, restaurants, federal buildings have figured out ways of accommodating real American citizens without restricting them to single ID cards. And as a fundamental constitutional right, so should all elections in the country. The airplane analogy is also beside the point. This is the last thing I'll mention. Voting is in 2 articles of the Constitution and 10 amendments of the Constitution. It's featured at the very heart of our constitutional order. Boarding a plane is nice. Drinking a beer is very nice. But outside of prohibition, I don't see that in the Constitution. None of the laws that I've mentioned today, none of the laws here make it 100% impossible to vote. But for many, as a practical matter, they do make it very, very difficult for no good reason. We all deserve better when it comes to our most fundamental constitutional guarantees, and I thank you very much for investigating this issue.
Thank you very much, Professor Levitt. I read your testimony in its entirety, and I know it's exhaustive in terms of the research you've done. I thank you for that very much. I found Congressman Rokita's statement hard to rationalize when he said along the lines that we shouldn't really count the fact that people aren't prosecuting voter fraud because, you know, it's not worth prosecuting. He talked about, you know, witnesses hard to come by, and we shouldn't be concerned that there's no evidence of prosecution of fraud. And yet, state after state is being urged to change the laws and impose new burdens on innocent people all across the state because of allegations of fraud, which is, quote, not worth prosecuting. I don't think you can have it both ways. If this is clearly designed to stop some terrible miscarriage of justice at the polling place, then it ought to be prosecuted. And there ought to be a clear example to the people of this country that we just won't stand for this wherever it might occur. Mr. von Spakovsky, let me go back to a movie whose name I can't recall, where the seminal phrase was, "Show me the money." Remember that one, Al?
Jerry Maguire.
Oh, I knew he'd know it.
I'll take movies for 200. I'm sorry, what was Jerry Maguire?
So let's follow the money in this debate for a moment. Let's see who is pushing for these changes in the law and where the money's coming from, and see if it gives us any kind of an indication of a political motive behind this. Are you familiar with a group known as the American Legislative Exchange Council?
Certainly, Senator. It's the equivalent of the National Conference of State Legislators. It's a similar trade organization for state legislators.
And one of the founders, Paul Weyrich, you familiar with this man?
Certainly, he helped start the Heritage Foundation, too.
And one of the preeminent conservative political spokesmen in America, who said in a moment of candor, "I don't want everybody to vote. As a matter of fact, our leverage in the elections quite candidly goes up as the voting populace goes down." Thus, quote, the quote comes from Paul Weyrich, one of the founders of the American Legislative Exchange Council. Then you take a look at where the money is coming for this council to undertake these legislative efforts all across the United States, and you find a couple brothers, David and Charles Koch, billionaire conservative financiers who have spent substantial sums of money, even before Citizens United, to promote a pretty conservative political agenda. Now take a look at the people most affected by these new laws. You've heard it said over and over again. I think you've said it in your testimony. I'll just tell you, as a sophomore student of political science, I would bet the people we're talking about are more likely than not to vote on the Democratic side. Not all of them, by any means, but more likely than not. So is this a great leap to put these two things together? That these two financiers, through this council, spending millions of dollars, are promoting changes in state law that will restrict the outcome of elections when it comes to Democratic voters?
Senator, you can do that with any subject in America. In fact, there's a famous
do it with this subject.
Hollywood thing. I'm 7 stages removed from which actor is it?
It's Kevin Bacon.
Good.
It's not 7, it's 6.
6. Very good. I don't believe that the Democrats in Rhode Island, who control the state, I think 4-1 in the state legislature, would agree with that. They are the ones who thought this bill was necessary. I've read you some of the quotes from the legislators who were in favor of this. Same thing happened in Kansas. Democratic legislators also voted to approve this voter ID legislation.
Do you dispute my premise that the American Legislative Exchange Council has played an active role in the promulgation of the state laws that we are discussing here today?
Senator, they have a lot of model bills that they recommend to their state legislators.
I'll take that as a yes.
Yes, and those are approved by votes of their state legislators at their committee meeting.
And do you also concede the fact that the Koch brothers are major financiers of conservative causes, including this council?
I have no idea, Senator. I don't keep track of major contributors to organizations like that.
We do. And I would like to ask you as well, do you not note that the people we're talking about, by and large, whether African American, poor, elderly, and such, have generally inclined toward voting on the Democratic side? Do you dispute that?
I don't dispute, Senator, that, for example, probably upwards of 90% of African Americans in this country vote Democratic. But what I am disputing is the idea that voter ID, for example, depresses their turnout. The actual numbers in elections in Georgia and Indiana since the voter ID laws have been passed show that that is not true. There's been significant increases in the turnout of African American voters in those elections. And if the premise that is being made here were true, that in fact this depressed their turnout, then that would have happened. It has not happened in those states. In fact, the University of Missouri did a study of Indiana shortly after the voter ID law went into place, and they found that there was no statistically significant showing that that was occurring. In fact, the only thing that came close to being statistically significant was the fact that turnout seemed to go up in predominantly Democratic counties.
Professor Levitt, what's your response to the turnout defense?
Well, this is where I pointed out the statistical flaws. There's a basic, and I mean basic, misconception here. It's called the correlation causation fallacy, and anybody who's had statistics for a week can talk to you about it. Yes, so Mr. von Spakovsky and I agree on one thing, that the turnout studies don't show a great impact, but that's because they can't. There are so many different factors that go into an election that when you only have 2 or 3 data points, Georgia before and after, Indiana before and after, that you can't draw any real conclusions about that. Give you an example. Mr. von Spakovsky supports ID restrictions. I oppose them. Mr. von Spakovsky has no facial hair. I have facial hair. But certainly opposition to photo ID doesn't cause facial hair to grow. They're simply unrelated. The 2008 election in particular is a particularly bad example. Georgia and Indiana were battleground states for the first time in decades in a presidential election, and minority turnout in those states would have been buoyed through the roof with a presidential candidate at the top of the ticket for a major party who was himself a minority. Under any circumstance, in Georgia and Indiana in 2008, turnout should have shot up. And the fact that it went up in Georgia by about 19% doesn't tell you anything about whether it would have gone up by 17% plus 2% for ID, or 35% minus 16% for ID. That is, you just can't know what effect ID is having with such a massive, overwhelming output of minority voters like that.
So let me ask you this question on early voting. It appears that consciously these legislatures are denying an opportunity for early voting on the Sunday before an election. And it's been stated by Ms. Brown-Deannis and others, I think you may have stated yourself, that in many minority communities, people go to church and then proceed to go to early voting. So is the premise here that there is more fraud in early voting on Sunday than there is on another day of the week? Or I'm trying to follow the logic of this effort to restrict early voting.
It's tough to follow that logic because I'm not sure I see any logic there. So I haven't heard it justified based on fraud, although I've heard just about anything else justified based on fraud. I have heard it justified based on cost, but the important thing to note is that this actually restricts flexibility. You heard from several members of the first panel that election administrators love opportunities when it's up to them to expand early vote because it helps smooth out the profile, because it helps get people in when they don't have to pay overtime, because it helps them actually process voters as voters want to come in, and because it helps them serve their constituents. And in Florida, election administrators had the flexibility. The law allowed them to offer 8 hours of early voting over the weekend. They could choose to offer it on Saturday, or they could choose to offer it on Sunday. And in at least 10 counties, including the most populous counties, election administrators thought they could best serve their constituents by offering on Sunday. They no longer have that latitude. And the impact on the minority communities is striking. In my written testimony, I've explained, in 2008, 13% of African Americans were the total electorate. 31% of the final Sunday were African Americans. Latinos were 11% of the total electorate, 22% of the final Sunday, double the impact. And 2008 was a banner year for minority turnout. Look to 2010, same pattern. 12% of the electorate were African Americans, 23% of that final Sunday. And for Latinos, 9% of the electorate and 16% of the final Sunday. The minority communities come out to vote on that final Sunday, and now they can't.
Senator Franken.
Thank you, Mr. Chairman. I unfortunately have to go in about 5 minutes because I have an important call, so thanks. Professor Levitt, that there's a lot of talk about this is a matter of confidence because whether or not there have been because we can't find any convictions on voter fraud, and so this is a matter of confidence. Do you think that it erodes confidence when people allege voter fraud and there doesn't seem to be any convictions for it, and there's no, and who tends to allege voter fraud more in your experience in this field?
Well, unfortunately, in my experience, every time a candidate loses their allegations of voter fraud, at least that's the most common. I do think it erodes confidence when people allege voter fraud that isn't there. And in fact, you'll see election administrators really fighting very strongly allegations of voter fraud when they know they've run clean elections. And they later turn out to explain that all of these allegations just disappear. They're easy to make just after elections, and then they vanish thereafter. I can also tell you that it's often asserted that we need ID laws in order to promote voter confidence. But here, too, I fall back on facts. It's a crutch I have. Professor Stephen Salabaher and Professor Nate Persley wrote an article in the Harvard Law Review examining the data. So they asked people, how confident are you in the elections? And they looked at the photo ID laws in those states. And they found no correlation whatsoever. It turns out that if you believe the election is stolen, you believe it no matter what the legal regime is. And if you believe it was fair, you believe it no matter what the legal regime is. So it just doesn't have that effect.
Okay, thank you. Mr. Von Spakowski, in 1982, this Congress amended the Voting Rights Act to prohibit not just voting practices with a discriminatory intent, but also those practices that disproportionately hurt minority voters regardless of intent. In 2006, the Senate reauthorized that law by 98-0. It wasn't a voice vote either. It was 98-0. Mr. Von Spakowski, we've heard some very persuasive evidence from your fellow witnesses today that these laws, from voter ID laws to restrictive registration laws, disproportionately hurt minority voters. Do you think that they comply with the letter and the spirit of the Voting Rights Act as amended and overwhelmingly reauthorized by Congress?
I would agree with Judge Harold Murphy, who was a federal judge in Georgia, who found that, in fact, Georgia's voter ID law was not discriminatory, and that's why he threw out all of the claims that had been made against it, that it was discriminatory, and, in fact, that decision was upheld by the 11th Circuit. So you don't need my opinion. That's the opinion of a federal judge who not only examined that law, but held very detailed and very lengthy hearings and looked at all of the evidence that a number of groups tried to present in court, including the ACLU and the NAACP, to show that it would have a discriminatory impact, and the judge concluded that they were unable to prove that it did.
Mr. Levitt, what do you have to say to that?
So it is true that the court did find that there was no violation of Section 2 of the Voting Rights Act. I'll say that it didn't credit much of the evidence of burden about going to get a photo ID for those who didn't have that, and there are voters in Georgia for whom this is quite burdensome. There's a different provision of the Voting Rights Act, Section 5 of the Voting Rights Act, that the court didn't have a chance to address because the Department of Justice is the only entity that has a chance to address it if it signs off on a law. That was a very controversial preclearance exercise. I believe that there was a staff memo, not normally leaked, but in this case leaked to the public, that came in recommending that the law not be precleared. And then the very next day, so a 70-some page staff memo, the very next day, the law was precleared without objection. And that decision never got a second hearing in a court. There's no jurisdiction to give that decision a second hearing.
I see. I wanted to go back. I know that Mr. Levitt talked about this, but this was the use of the number of additional votes in 2008 in Georgia's black population. Mr. Von Spakowski, do you think that part of that might have been because of that Georgia was targeted as a battleground state and hadn't been for a long time?
Well, let me make 2 points. I mean, first of all, Mr. Levitt said, well, I was only talking about 1 or 2 data points. Well, that is untrue. I mean, there are a number of studies that have been done, including one by the Heritage Foundation, that looked in turnout over more than one election in all 50 states, including a study that I looked at earlier, I mentioned earlier, University of Delaware, University of Nebraska. They looked at turnout in the, I think, 2002, 2004, 2006 elections, and all concluded that it did not depress the turnout of voters across socioeconomic lines. Now, with regard to Georgia, we had a great turnout in the 2008 election. In fact, we had one of the highest turnouts in decades. But the turnout in Georgia went up in comparison to other states that also went up. I mean, for example, Mississippi, neighboring state, large African-American population, just like Georgia, the increase in turnout there was only about a third what it was in Georgia. Indiana...
Can I ask you something?
Sure.
Do you know how much Mississippi grew in terms of black population during those years versus Georgia?
I don't, but I do know...
Excuse me.
Yeah.
I'm sorry. Wouldn't that have to factor in then to the significance of that?
It certainly does, but the Georgia Secretary of State recently noted that, in fact, for example, in the 2010 elections, the turnout of African Americans outpaced their growth in registration by like 20%.
Here's my question. You did a study and you put in your testimony that it was significant that the percentage of black voters grew more in Georgia than in Mississippi. You just cited it again. But I would think that as someone who writes studies, that it would be significant just to know that the black population in Georgia grew at more than 4 times the rate than the black population in Mississippi. And I'm wondering how you didn't factor that in and put all kinds of significance into the fact that the percentage of blacks who voted grew more in Georgia than in Mississippi, when in fact Georgia was, I think, the second highest next to Kentucky in terms of the percentage of growth of black population during the last decade.
Well,
don't you think that that's a little sloppy, that you put that in without noting that Georgia grew at more than 4 times the rate that Mississippi did? And didn't that create an inference? I have to go. I'm sorry. I mean, doesn't that create?
Do you want me to answer the question or not? Or
it's I'm sorry. It's more than 3 times the rate, not 4 times the rate. I apologize.
Well, I mean, all you're telling me, Senator, is that the increase in turnout kept up with the rate of growth, which is just another sign that it did not affect or depress the turnout.
Yeah. Well, I was basically kind of saying that you put something in your testimony that suggested something that wasn't necessarily that created an inference that wasn't true.
Well, I would disagree with that, Senator.
Yeah, but I think it's hard to really argue with it because you didn't note that Georgia's black population grew at a much, much, much faster rate than Mississippi's, and yet all you did was put that their black voting rate increased more, and I think that's creating an inference that either you knew it or you didn't know it, but I think you should have checked it out.
Thank you very much, Senator Franken. I appreciate your coming and your patience, and I want to ask a few more questions. And Ms. Brown-Deannis, you're not going to get off the hook. You were invited to be part of this panel, and I'd like to hear your comments. You probably heard Senator Bill Nelson speak about the situation in Florida and voter registration. And I'm concerned that a group like the League of Women Voters would decide to get out of the business. And I'm also concerned that there are many other organizations, nonpartisan organizations, focusing on voter registration that may share their concerns when you impose burdens like the new Florida law does impose. So if I can ask you to comment on the impact of these new voter registration standards. They've been alluded to here, turning in voter registration within 48 hours and the like. If you could comment on what impact this is likely to have on voter registration turnout.
Sure. As Professor Levitt mentioned, this actually was not the first time that the Florida State Legislature tried to increase the penalties for voter registration groups and the burdens on them. However, Advance Project and the Brennan Center sued on behalf of the League of Women Voters before, and we were successful in settling that case. We believe that what will happen this go-around is that there are a number of requirements that groups did not have heretofore that really kind of very much liken this to Jim Crow registration requirements of the 50s and 60s, where, first of all, groups will have to go and register as registrars in the state and go through a process of burdensome process of filling out paperwork, not making it very easy for groups. Second, that there is a 48-hour turnaround for groups to turn in completed registration forms. Of course, there's some concern. First of all, it had been 10 days. Where a registration group could go and take its forms, make sure that it had high quality. This is part of the problem, is that this is going to chip away at the quality of voter registration that groups are doing. Because often the best voter registration groups, and I've seen this in the state of Florida, take these voter registration forms, make sure that they're filled out completely. If they're not, they go back to the person that was registering to get the missing information before they hand it in to the registrar, thereby cutting down the work that the registrar may have to do in filling out incomplete forms. What it will also do is that it will increase the penalties, actually the cost and the fines that registration groups will encounter if they do not turn in the registration forms within these days. So if you're looking at this as the League of Women Voters, the NAACP, other nonpartisan groups, and thinking about what is the cost to us of messing up one time or two times. It may not be worth it. And so to have an organization like the League of Women Voters, who's been doing registration in Florida for over 60 years, pull out of Florida is very devastating. And this is about whether or not people will have access. And again, as I said in my testimony, African American and Latino voters are more likely than white voters to register through registration drives than going into the motor vehicle office or some other agency to do the registration.
So what have you found in this advancement project that you're part of in terms of the incidence of voter fraud? Professor Levitt and Mr. Van Spakowski obviously have a different point of view. What have you found?
Sure. We have looked at the studies. We've looked at what the Department of Justice did during the Bush administration in its 5-year investigation of voter fraud, came up with very little voter fraud. One thing that was mentioned earlier was the issue about a Cuban coming to America and registering to vote. The photo identification requirement does not help that. What helps that is that federal law requires, under the Help America Vote Act, requires that you provide either a driver's license number or your last 4 digits of your Social Security number that can be matched against your name. And so there are other things in federal law that really that deal with these issues that we don't have to go to photo ID. And again, it's about whether or not we have multiple forms of identification. Professor Levitt got on a plane with multiple forms, not just that one ID. And so, again, it is the solution without the problem, and there's not documentation. In Indiana, they could not come forward with a case of impersonation in front of the Supreme Court. So if they can't find the cases, they don't exist, because I'm sure they've been looking for them for a long time.
I sent a letter to a number of governors as a result of this hearing, asking them for some information about what's going on in their state where these laws are being changed. I hope they respond. I want to make particular note of a neighboring state to Illinois, Wisconsin. Wisconsin has a state agency, the Legislative Fiscal Bureau, and they determined that 20% of the people living in Wisconsin do not possess the kind of identification required by the new Wisconsin law. That includes 177,000 elderly people, 36% of young voters, 70% of African Americans under the age of 25, and approximately 242,000 Wisconsin college students whose student ID cards do not meet the strict new requirements in Wisconsin law. Let me go to student ID cards for a minute here. It seems to me that these states are going out of their way not to acknowledge IDs issued by state universities. Texas is a good illustration. Your ID at the University of Texas doesn't meet the test. However, your application for a firearm, that ID does meet the test. Can we draw any political conclusions from that? I'd like to ask you, when you take a look at where this is headed, is it a leap to suggest that these laws are more restrictive in terms of potential Democratic voters?
It's not a leap. When you look at the groups that will be disproportionately impacted by these laws, Black voters, Latino voters, young voters in states like South Carolina, Texas, and Wisconsin, where they will not be able to use their student IDs. There clearly is a correlation, because those are the groups that we saw a surge in voter registration in 2008, and we saw a surge in turnout. And so there's real concern that this was targeted at these folks so that they will not be able to participate in such great numbers in 2012.
Now, one of the things Wisconsin made a point of doing was saying we're not going to charge for the ID card. That was smart, because I think that would have just fallen on its face as basically a poll tax. You have made the point, and others have made the point, that going to get a birth certificate is not a free enterprise. You end up paying for it, usually, if you need one to prove your identity for one of these state ID cards. But there's also another element, and I'll give you an example here in Wisconsin. There's only one DMV office in the entire state of Wisconsin that is open on weekends. One for the entire state. More than half of the DMV offices open during the week only have part-time hours. 3 counties have no DMV office at all. So I've written to the governor and asked him, you're considering closing more DMV locations because of budgetary problems. How are you going to accommodate the issuance of IDs to 1 out of 5 people in Wisconsin who don't have them? Is this a problem beyond Wisconsin?
Sure. As I mentioned earlier, in Texas, it is also a problem where 80 counties have either no DMV office or have closed their DMV offices. Of course, as we see the cutbacks in budgets across the country, we will see more of these offices closing. And when you look at the correlation, and actually it's in my testimony, the correlation between race and where those offices have closed, you will find that there are disparities in the impact of the closures of those offices, thereby making it more difficult for African American and Latino would-be voters to actually get their ID.
Mr. von Spakovsky, you said that photo ID laws increase public confidence in elections. But if that's the case, what impact does disenfranchising people who can't make it to these DMV offices because of inconvenient locations or inconvenient opportunities, what impact does that have on public confidence in elections?
Well, I think as I've said, both in my written testimony and here today, those claims are quite frankly bogus, Senator. Let me read you a quick quote from the Indiana Federal District Court that said this: despite apocalyptic assertions of wholesale voter disenfranchisement, plaintiffs have produced not a single piece of evidence of any identifiable registered voter who would be prevented from voting pursuant to the photo ID law. All of the same claims being made here today, that there are huge numbers of people without photo ID, that they won't be able to vote, were made not just in the Indiana case, but also in the Georgia case before Judge Harold Murphy, who, by the way, is not a conservative judge. He's a Carter appointee, and in fact, the plaintiffs in that case venue shopped to file their case up in a small town in the northwest corner of Georgia, specifically to get that particular judge. And he also said that this failure to identify those individuals is particularly acute in light of the plaintiff's contention that a large number of Georgia voters lack acceptable photo ID. In both cases, when it actually came to not making claims, but producing actual evidence that there are large numbers or even a single individual that would not be able to meet these photo ID requirements because they either didn't have a photo ID or couldn't easily obtain one, these organizations were unable to do so, and that's why those laws are in place and haven't been in place now for several elections in both states.
Now, your first quote was from the Crawford versus Marion County Election Board case, which considered Indiana's photo ID law. And you cited that case to support your point that photo ID laws don't prevent people from voting. And you quoted the court's statement to that effect. Your citation is misleading because the Crawford case was filed before the Indiana law was even implemented. Isn't it true that in Crawford there were no plaintiffs that had been harmed by the photo ID law because the election in Indiana hadn't occurred and Indiana's voter ID law hadn't been implemented?
Well, I would refer you to what Congressman Rakita said earlier. They could, any groups, the same groups who contested the case before the U.S. Supreme Court could have, within the last few years, have filed an as-applied challenge based on actual individuals that they claim are unable to vote because of the law. And as Congressman Rakita said, where are the suits making that claim?
Professor Levitt?
So it's a little odd listening to Mr. von Spakovsky begging for more litigation. I think your point's exactly right, that the suit was brought before there was ever a chance to enforce the law. That may or may not speak to particular plaintiff strategy, but it doesn't speak at all to whether there were actual voters burdened. It's also important to listen to the quote, and Mr. von Spakovsky quoted accurately, but the judge said there's no individual prevented from voting who's been put before the court. There were plenty of individuals, mostly in amicus fashion, who would have had a really, really hard time. And the court essentially set a higher standard than public policy should ever set in determining that it was only going to look at people who were locked out, no point of return, not caring about the individuals who would be substantially burdened. And there are real individuals. Since that case was brought, We know that there have been individuals without ID who have tried to vote and failed. Real people. Retired nuns in South Bend in 2008. I believe that there were at least 10 of them turned away, and one of the nuns who was turned away noted that many others among the 137 retired sisters living at the Congregation of Sisters of the Holy Cross Convent were dissuaded from voting upon learning that their sisters had been turned away. That is, never showed up to cast a provisional ballot. We don't have the evidence that they tried to vote because sisters came home and said, hey, we just went down to the polls and we couldn't do it. Chris Conley, a 50-year-old veteran of the Navy and Marines, tried to vote in Indiana's 2008 primary, but his Veterans Administration photo ID card didn't have an expiration date, and so he wasn't able to cast a valid ballot. Now that's just one example here. There are many others that I've put forward in my written testimony for you, but I frankly think it's shameful to conceive of even one veteran who's served our country and watched brothers and sisters die to preserve others' right to vote, turned away for no good reason. And yes, it is true that Mr. Conley didn't bring a lawsuit, but that shouldn't be the standard when looking at whether these laws are rational, whether they're good public policy, and even whether they're constitutional.
I want to thank this panel for joining us today and being part of what I believe may be the first hearing on the subject on Capitol Hill. I hope others will follow. What is at issue here goes beyond the ordinary fare of these committees, as important as it may be, because the right to vote in America has been described as the right preservative of all other rights. It really is fundamental. It goes way beyond getting on an airplane or anything else that we might do. And that's why I think it should be treated with extreme care, and each generation should accept the responsibility to make certain that we preserve this right to vote for all those in America who have fought so hard to maintain it over the years and who honor it as we do. Dozens of organizations are on the ground educating the public, challenging these laws, and fighting to preserve the right to vote for all Americans. Many of them have submitted statements, including Lawyers Committee for Civil Rights Under the Law, the Leadership Conference on Civil and Human Rights, the Brennan Center for Justice, Rock the Vote, DEMOS, AARP, Fair Elections Legal Network, Constitutional Accountability Center, United States Student Association, Human Rights Campaign, NAACP Legal Defense and Education Fund, the League of Young Voters, America Votes, District Supervisor Nikki Harris of Milwaukee, Campus Progress, National Coalition of the Homeless, National Action Network, National Coalition on Black Civic Participation, and without objection, I'll make these statements that they've submitted part of the record. I thank these organizations and especially thank the witnesses for the sacrifices they made to come here today and be part of this important hearing. The hearing record will be open for 1 week to accept additional statements. Written questions for the witnesses may also be submitted, and I hope they can respond in a timely fashion. If there are no further comments from those on the panel, I want to thank our witnesses again for attending and all those who are here today and my colleagues for participating. The hearing stands adjourned.